Welcome back to the deep dive. We're continuing our journey through the MPEP, the Manual of Patent Examining Procedure. Today, we're really getting into the groundwork, the absolute foundation for how you interact with the USPTO. We're tackling Chapter 400, specifically Section 402, Power of Attorney, Naming Representative. Basically, who gets to speak for you, the applicant or owner, at the patent office? And believe me, the rules are tighter than you might think. Our goal today: unpack these rules, spot the pitfalls, and understand why getting this right is so critical from day one.
Absolutely. And this isn't just, ticking a box on a form. Section 402 is really about procedural integrity. If that power of attorney, the POA, isn't valid from the start, well, everything else can unravel. Think about it. Correspondence, deadlines, actions you assume your representative is handling, all potentially void if that initial appointment is flawed. It truly underpins reliable communication.
Okay, let's get into the nitty-gritty then, the anatomy of a valid POA. The MPP gives us 3 ways to do this correctly. Who exactly can be named?
Right, it's quite specific. 3 options. First, pretty straightforward. 1 or more registered patent practitioners. These are your patent attorneys or agents listed with the USPTO. Second option, you can name 1 or more of the joint inventors themselves. And third, which is often the most practical route, especially for organizations, is naming all registered practitioners associated with a specific customer number.
Okay, the customer number sounds efficient. But before we get there, you mentioned practitioners. This is where that infamous size limit comes in, right? The one that catches people out?
Exactly. This is a big one. The MPEP is very clear. Powers of attorney trying to name, say, an entire law firm as an entity or an organization, or even just listing more than 10 individual practitioners by name, they're generally not recognized.
Not recognized. So if I list 11 names, the whole thing is invalid.
Pretty much. The office won't accept it as establishing representation for those individuals listed that way. It fails.
Okay, hold on. How does a huge law firm with, 50 patent pros manage this? Surely they don't file 5 separate POAs listing 10 people each. That sounds insane.
Right, that would be unworkable. And that's precisely why the customer number system exists. It's the main workaround, the strategic solution. If you use a customer number associated with the firm, that POA effectively appoints everyone on that firm's list tied to that number. It completely bypasses the 10 individual name limit.
Ah, I see. So the customer number acts like a master key linking to the firm's registered list, however long it is.
Exactly. It lets the firm manage its roster of practitioners internally under that number, and the applicant just points to the number.
So the applicant doesn't have to constantly update the POA every time someone joins or leaves the firm's patent group. The responsibility shifts to the firm maintaining its customer number list correctly.
Precisely. It maintains accountability for the office, but streamlines the administration massively, especially for complex cases or large portfolios. Makes life much easier.
Okay, so we've covered how many people can be named, essentially. Now let's pivot to who they need to be, professionally speaking. It's not enough just to be named, right? They need the right credentials.
Correct. Just being lifted isn't sufficient. They have to meet specific qualifications. The core rule is they must be properly registered to practice before the USPTO. That's laid out in 37 CFR 11.6. That rule covers the ethical standards, the technical qualifications, passing the registration exam, all that jazz.
But it's not just any registration, is it? There's nuance there, too.
Yes, and this is becoming increasingly important. They need to be qualified for the specific type of matter. You can't just assume any registered practitioner can handle any case.
And this ties into that big change from early 2024, doesn't it? The design patent bar.
Exactly. Since January 2nd, 2024, we have the specific design patent practitioner bar. If someone qualifies only under that design bar, their practice is explicitly limited. They can only represent clients in design patent matters, not utility patents, not other types.
That really highlights the specialization requirement. Makes sense, design is different. Okay, but what about the flip side? What if someone is properly registered, named on a valid POA, but then something goes wrong? Like they get suspended or disbarred?
That's a critical failure point.
Yep.
If a practitioner loses their good standing, suspended, disbarred, whatever, any POA naming them instantly becomes ineffective, void.
Wow, instantly. So the office doesn't, send the applicant a courtesy note saying, hey, your lawyer's out, find a new one.
Nope, no warning like that.
No.
The procedural consequence is immediate and direct. Correspondence just stops going to that practitioner or their firm via that POA. Instead, the office redirects all mail to the first named applicant on the application.
Ouch. So official actions, notices, deadlines, suddenly they're landing in the inventor's mailbox who might have no idea they're supposed to be looking for it or what to do.
Precisely. Deadlines can get blown very easily if the applicant isn't aware or prepared. It's a huge risk if you're not somehow monitoring your representative status.
That really drives home that the practitioner standing isn't just their problem, it's the applicant's risk too.
Okay, let's switch gears slightly. What about invalid appointments from the get-go? Like when someone tries to name the wrong kind of person entirely.
Yeah, that happens especially with folks trying to file on their own. If an applicant names someone who is not a registered practitioner and not one of the joint inventors, well, the office simply won't recognize that appointment.
So like trying to appoint your cousin Vinny because he's good with contracts.
Exactly. Or, the inventor tries to name their business partner who isn't an inventor or registered, or that smart neighbor you mentioned earlier. Doesn't matter how much the applicant trusted them. If they don't fit into those allowed categories, the appointment is void. Kaput.
And what happens then? Correspondence-wise. Same outcome as with the suspended practitioner, effectively. The office ignores the invalid appointment and sends all correspondence directly to the applicant. And this really underscores the MPEP's underlying advice here. Seriously consider getting a registered patent attorney or agent. Proper prosecution is complex, and trying to navigate it with someone unauthorized is just asking for trouble.
Makes sense. Protect your invention, use the right tools. But, rules always seem to have exceptions. What about this limited recognition thing? Sounds like a temporary pass.
It sort of is, yeah.
Yeah.
Limited recognition falls under 37 CFR 11.9. It allows certain individuals who aren't fully registered practitioners to represent applicants in specific situations. Think, for example, maybe a foreign patent agent who needs authorization for a particular case, or someone under specific supervised practice rules.
So it's not a general license. What are the strings attached?
Are definitely strings attached. It's under very tightly controlled conditions. The recognition is usually tied to specific applications only. And crucially, it automatically terminates if the basis for that recognition changes, like if their authorization from their home country lapses, or maybe their immigration status changes if that was relevant. It's narrow and conditional.
Okay, conditional and specific. Got it. One last related point from Section 402. Sometimes practitioners can sign things even without a formal POA, right? How does that work?
That's acting in a representative capacity under 37 CFR 1.34. Yes, sometimes a practitioner can sign certain documents for the applicant even if there's no POA filed for them in that specific case. But, and this is key, it's only for certain types of papers, usually more procedural or minor things as defined by the rules. And they must be acting on behalf of all the applicants listed. It doesn't grant them the full authority to prosecute the application like a formal POA does under Section 402. That still requires the proper, valid power of attorney we've been discussing.
Okay, pulling it all together, Section 402 really sets the stage. It's all about defining that official link between the applicant and the USPTO, making sure everyone knows who has the authority to act. It's about accountability and keeping the process orderly.
Absolutely. It locks down that crucial relationship, protecting the applicant's rights, but also ensuring the office has a clear, reliable point of contact.
Before we wrap, we definitely want to give a special thank you to Mike Shepard. He's the creative director who organized this entire MPEP audio series. His vision and hard work made this structured deep dive possible.
Hear, hear. And now for the necessary legal bit. Please note, this summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.
Right, always check the source. And finally, to leave you with something to think about, building on that risk we discussed earlier, we know a suspended practitioner's POA just evaporates and the critical mail suddenly reroutes to the applicant, potentially unnoticed. So here's the question. Given how vital USPTO deadlines are, what proactive steps, what checks and balances should you as an applicant or patent owner have in place to monitor the ongoing good standing of your representative? How do you protect yourself when the ultimate responsibility lands back on your doorstep? Something to ponder as you navigate the patent world. Join us next time for another deep dive.